The number you have reached, 911, has been changed to a non-published number.
Next, we get to procedures, or criminal procedure. In the pretrial, we have Wade against Commonwealth in the Court of Appeals, and it's about indictments. And in this case, basically say, there is no distinction between an accessory and a principal for a misdemeanor. If a defendant doesn't act, which would be an accessory or a principal in the second degree, he is a principal in the first degree under misdemeanors. And while 18.2-23 lays out a punishment for conspiracy to trespass, this is only showing the punishment for conspiracy to trespass. It is not showing that there are no conspiracies for misdemeanors. Now, and that's in footnote 2. It's kind of a throwaway. That's going to be a shock to, I think, a fair number of Virginia lawyers who've taken it as gospel for a while that there are no conspiracies for misdemeanors. You can't be convicted for conspiracy for misdemeanor. In this footnote, at the very least, the Court of Appeals has said, yes, there are. All 23 says, 18.2-23 says is the punishment for the trespass misdemeanor conspiracy is a Class 3 misdemeanor. Next, under indictments, we have Atkins against Commonwealth again. This is again is Virginia Court of Appeals, and this is about mandatory minimum sentences. And Atkins says that just because the establishment of a certain element will trigger a mandatory minimum sentence does not mean that that element has to be in the indictment. Because mandatory minimum sentence is only a part of the range of the punishment. It doesn't extend the punishment above where it would have been before. Next, we have jurisdiction, and that comes from Kelso against Commonwealth from Virginia Court of Appeals, and it basically says that while subject matter jurisdiction is not waivable and can be raised at any level, territorial jurisdiction is waived if it isn't raised in the trial court. So basically, if a general district court judge in Virginia were to try a jury trial on a felony charge, something absolutely could not do, he would be outside of his subject matter jurisdiction, and therefore, at any point, that jurisdiction could be raised as absolute way of breaking that conviction. On the other hand, if a circuit court judge is sitting in, Powhatan, Virginia, and he hears a case from Russell County, Virginia, which are approximately 5 hours away from each other, maybe. If the defendant does not raise the territorial jurisdiction argument at trial, he's waived it and lost. Venue. Okay, and we also have Kelso against Commonwealth Court of Appeals talking about venue as well. Venue is not a substantive element of the crime. It doesn't have to be proven beyond a reasonable doubt. Prosecution only has to produce evidence sufficient to give rise to a strong presumption that the offense was committed within the jurisdiction of the court. And that strong presumption can be proven through circumstantial evidence or direct evidence. I'm not sure exactly what strong presumption means. Probable cause? Preponderance? Clear and convincing evidence? Apparently not beyond reasonable doubt. Strong presumption could mean any number of things. Okay, so we get to procedure and trials, jury instructions, and we have Alfred against Commonwealth, and this is Court of Appeals again. If the defendant agrees to an erroneous jury instruction, he cannot appeal on the basis of that erroneous jury instruction. The ends of justice exception only allow an agreed upon jury instruction to be appealed if a proper jury instruction is absent and the evidence falls short of failing to prove an element of the crime. Basically, the ends of justice exception on an agreed upon jury instruction is only allowed if the defendant affirmatively proves that an element of the crime did not occur. Sentencing. In sentencing, we get a judicial imposition of the sentence, an allocution. Montgomery against Commonwealth from the Court of Appeals. Allocution is not a constitutional right; it's just a statutory right that's given by, so it has no constitutional weight. Failure to allow the defendant to have an allocution is a trial error, not a structural error, and therefore it's subject, when it goes to the Court of Appeals, to harmless error analysis. In other words, structural error is when you tell the defendant, no, you can't have a jury. That's a structural error, and there ain't no harmless error analysis when you go to the Court of Appeals and something like that. Trial error is when you do something like make an error on an objection or something like that, and they decide that this is not a structural thing; it's just an error on the level of making an error on a hearsay exception. To preserve an allocution error, the defendant must both object and proffer the statement that would have been made. If the proffer that is made is one that would mitigate the offense, I'm sorry that I did this, I hurt my mom, I should have never done that, I was the getaway driver, not the guy who went in the bank, like they say, something that would mitigate the offense, then the judge must indicate that he's not going to consider it, or else if he indicates he has considered it, there's no error, and if he didn't give a proffer, then the appellate court says it doesn't have anything to decide whether there was an error or not at all. And in this case, because the defendant didn't argue that deprivation of allocation violated due process, he waived that and didn't get to make that argument during his appeal.